Imagine a bank lends out 50 million rupees.
Right. A pretty standard Tuesday in the corporate world.
Yeah, exactly. So the paperwork is signed, the collateral is all locked in, and the executives are happy. But then a mid-level bank officer notices, like a minor typo on the date of the guarantee document.
Oh, I see where this is going.
Right. So trying to be helpful, they take a blue pen and just change a 4 to a 5.
Oh, wow.
Yeah. In that single well-intentioned second, that entire billion-rupee debt is legally erased. The bank is just, left holding a worthless piece of paper.
It is brutal. I mean, it's a brutal reality of commercial courts.
It really is. Today, we are taking you on a deep dive into the hidden tripwires of Pakistani banking and business law.
Because, we tend to think of business as just handshakes, relationship management, moving capital around.
Right.
But beneath all of that is this invisible, highly rigid architecture of legal definitions. A single misunderstood concept, like your pen example, isn't just a theoretical error in a textbook. It is a massive financial write-off.
And that is exactly our mission for this deep dive. We are unpacking a comprehensive educational guide, which is tailored specifically for you, whether you're a student or a professional, navigating this high-stakes environment in Pakistan.
Yeah, we're looking at the core statutory provisions from the Contract Act of 1872, the Negotiable Instruments Act of 1881, and the Sale of Goods Act of 1930.
But rather than just reading dry law to you, we're going to use memory hooks, contrast pairs, and strategic keys to show exactly how these mechanisms are actually weaponized in a courtroom.
Absolutely. And the best place to start is the absolute foundation. I mean, every single banking facility, every corporate guarantee, every letter of credit is, at its core, a contract.
Right.
But a critical distinction that always catches people off guard is the threshold between a mere agreement and a legally binding contract. The law is incredibly specific about what elevates a casual promise into an enforceable obligation.
Yeah, I love using the 5 fingers memory hook for this. Like, if you hold up your hand, you need 5 distinct elements to make a fist. And that fist represents a solid, binding contract.
I like that visual. So what are the fingers?
So first, you need free consent from both sides. Second, the parties have to be competent, meaning, no minors or individuals lacking mental capacity.
Right. Makes sense.
Third, there must be lawful consideration. Fourth, the object of the agreement has to be lawful. And fifth, the agreement just cannot be expressly declared void by the law.
Exactly.
If you take away even one of those fingers, well, you can't make a fist, and you basically have no legal standing.
That visual is highly effective because it treats the contract as this composite structure.
Yeah.
And out of those 5 fingers, consideration is usually where the most complex legal battles are fought.
Consideration, meaning the money.
Basically, yes. Consideration is fundamentally the price you pay for someone else's promise. When a bank promises to lend 50 million rupees, the price the borrower pays for that promise is the agreement to repay the principal with a markup. Both sides are exchanging a tangible price.
Okay, let me test the limits of that exchange for you. Let's talk about the limitation period in commercial debt. After a certain number of years, a debt just legally expires, right?
Yes, it becomes time-barred.
Right. The bank runs out of time to file a lawsuit. So at that point, the borrower is free and clear, and the bank just has to write off the loss.
Well, normally that would be the end of the road. But Pakistani banking law contains this massive strategic key. It's often known as the zombie debt.
The zombie debt.
Yeah. Under Section 25, subsection 3, if a borrower provides a simple written acknowledgement of that time-barred debt, like just a signed document recognizing the amount owed, it revives the debt entirely. It brings it back to life like a zombie.
Wait. But if consideration is the price paid for a promise, what is the bank paying the borrower to sign that new acknowledgement? The bank isn't handing over new cash, right?
No, they aren't. And that is the genius of the provision. The law explicitly states that this written acknowledgement of a time-barred debt does not require any new consideration to be binding. The original expired loan serves as the foundation. Furthermore, this highlights a vital contrast between Pakistani law and English law. English law generally requires consideration to be current or future.
But Pakistan doesn't.
Exactly. Pakistani law explicitly accepts past consideration.
So the past act serves as the price for the present promise. That totally changes the timeline of negotiations.
It fundamentally alters the strategy. Consider a scenario where a bank disperses a corporate loan on a Monday.
Okay.
By Wednesday, the risk department suddenly demands a personal guarantee from the company's director. In a jurisdiction that only recognizes present consideration, that director could successfully argue that they received no new benefit on Wednesday for signing the document, rendering the guarantee void.
Ah, because the money was already gone on Monday.
Precisely. But in Pakistan, the bank leverages past consideration. They argue the money disbursed to the company 2 days prior is a consideration for today's guarantee. The document is completely airtight.
That makes a lot of practical sense for, a fast-moving corporate environment where the paperwork sometimes trails behind the actual transfer of funds.
Absolutely.
So assuming we have all 5 fingers, we have consideration, we have competent parties, we have our fist. But let's look at the first finger, free consent. What if the consent looks real on paper, but was totally compromised behind closed doors?
That brings us to the vulnerability of consent. There are 5 specific factors that destroy free consent, and the memory hook here is CUFMM.
CUFMM.
Yeah. Coercion, undue influence, fraud, misrepresentation, and mistake. If any of those elements cause the signature to happen, the consent is just an illusion.
Okay, I want to clarify the line between coercion and undue influence because it seems heavily dependent on context.
It is, yeah.
Let's say a bank is dealing with a borrower who is severely defaulting. The bank officer calls the borrower and says, if you don't sign this new highly restrictive guarantee by tomorrow morning, we are reporting your default to the National Accountability Bureau, NAB, and you will likely be arrested.
Okay, a very real-world scenario.
Right. So the bank is using its immense institutional power over a desperate individual. So that is undue influence, right?
Actually, no. The courts view that very differently. What you just described is coercion under Section 15.
Wait, really? Coercion?
Yes. The legal threshold for coercion requires a threat of a criminal nature or unlawful detention. Threatening to involve a criminal investigative body like NA to force a civil signature crosses right into criminal coercion.
Oh, I see.
Undue influence under Section 16 is purely psychological domination. It occurs when one party holds a real or apparent authority over another's mind and uses it to gain an unfair advantage, but without ever making a criminal threat.
So undue influence would be more like, say, a majority shareholder using their psychological leverage and corporate dominance to force a junior partner into signing away their dividends.
Exactly.
Whereas coercion requires the threat of handcuffs or physical harm.
That is the exact distinction. And understanding how consent is broken leads us directly into the most important contrast pair in contract law.
The dead versus dying contracts.
Yes, which the law refers to as void versus voidable.
This is a fascinating mechanism. So a void agreement is born dead. Like if both parties make a fundamental mistake about a fact essential to the agreement, or, if you attempt to contract with a minor.
Right. Section 20 basically says it's dead on arrival.
Exactly. The agreement has zero legal effect from the moment the pen hits the paper. It's a corpse. Nobody can enforce it, and nobody can choose to revive it.
Yep.
But a voidable contract, which is what happens when consent is destroyed by fraud or coercion, is dying. It is completely valid and alive until the victim decides to pull the plug.
And the strategic power of a voidable contract lies entirely with the innocent party. The wrongdoer, the party who committed the fraud or applied the coercion, is legally trapped. They cannot cancel the contract.
Only the victim holds the kill switch.
Exactly. Imagine a bank fraudulently induces a corporate client into a complex investment product. A year later, market dynamics shift bizarrely, and that product starts paying out massive returns to the client, costing the bank a fortune.
Oh, the irony.
Right. But the bank cannot suddenly point to its own fraud to void the contract. The contract is voidable, meaning the client has the exclusive right to either let the contract live and keep collecting the profits or rescind it.
So the law ensures the wrongdoer can never benefit from their own misconduct. That is a brilliant structural safeguard for you to understand.
It really is.
But it raises a practical issue. Let's say the bank has a flawless contract, no coercion, perfect consideration. Enforcing that contract in a civil court can take like a decade of litigation in Pakistan. Banks just cannot afford to wait 10 years to recover liquidity.
They absolutely cannot. Civil trials involve endless evidentiary hearings. That bottleneck is exactly why the banking sector relies heavily on the Negotiable Instruments Act of 1881.
To avoid the courts.
To avoid the delays, yes. This is the legal architecture that allows banks to move money and secure debts with immediate certainty. We often refer to these instruments like promissory notes and checks as magic paper.
Magic paper, I like that.
And the ultimate position of power regarding this paper is becoming what's called a holder in due course, or HDC.
Right. Being an HDC is essentially buying an asset with a magically wiped history.
That's a good way to put it.
Because usually in property law, you inherit the problems of the previous owner. Like, if you buy a used car that was involved in 3 hidden accidents, well, you now own a car with a failing transmission.
Unfortunately true.
But if you are an HDC of a negotiable instrument, it completely severs the chain of liability. The new owner gets a flawless legal vehicle entirely free from any prior disputes between the original parties.
Achieving that status, though, requires strict compliance. Think of it as a vault door with 5 heavy locks.
Okay, what are the locks?
To become an HTC under Section 9, first, you must physically hold the instrument. Second, you must have paid value for it.
So it can't just be a gift.
Right. Third, you must have acted in good faith. Fourth, you must acquire it before its maturity date. And fifth, and this is crucial, you must have no notice of any defect in the title of the person who transferred it to you.
So if you know the original parties are in the middle of a lawsuit over that specific check, you fail the 5th lock.
Exactly. You do not become an HTC. You remain a standard holder. And a standard holder inherits every single legal vulnerability attached to that paper.
And the reason banks design their entire loan disbursement process around securing this HDC status ties into FRO, the Financial Institutions Recovery of Finances Ordinance. It is all about the burden of proof.
It is.
Because in a standard breach of contract case, the plaintiff has to prove everything. The bank has to prove they gave the money, prove the terms, prove the default.
But the Negotiable Instruments Act contains several legal presumptions that completely flip the script.
Which is where that huge mnemonic comes in, right? CDTTOSH courts defends the trustworthy original stamped holder.
Yes. Section 118 creates 7 presumptions, and the most devastating of these revolves around consideration, the C in your mnemonic. When a bank sues a borrower holding a valid promissory note, the court automatically presumes that the bank provided the consideration.
Meaning the bank does not have to submit bank statements or transfer logs to prove they handed over the cash.
Exactly. That completely shifts the strategy.
It puts the borrower in an almost impossible defensive position.
It does. The burden shifts entirely to the defendant to prove, beyond a shadow of a doubt, that they didn't receive the money. From a litigation standpoint, proving a negative, like proving that a conversation didn't happen or that a transaction never occurred, is incredibly difficult.
Wow. So that reversal of the burden of proof is the precise reason a bank will not disperse a commercial loan without a signed promissory note.
Never.
So the paper trail is essentially weaponized to bypass years of evidence gathering. But, paper only goes so far. If a commercial borrower goes completely bankrupt, the promissory note is just a very legally robust piece of paper that you can't collect on.
Right. You can't squeeze blood from a stone.
Exactly. The bank has to physically go after the assets. They have to liquidate the inventory. And that moves us out of the realm of abstract paper and into the physical reality governed by the Sale of Goods Act of 1930.
And grabbing physical assets is significantly messier than holding a piece of paper. The foundational rule of property transfer here is the legal doctrine nemo dat quod non habet.
Which translates to, no one gives what they do not have.
Exactly, under Section 27.
I call this the empty hands rule. If your legal hands are empty, meaning you don't actually hold the title to the goods, you cannot fill someone else's hands with good ownership.
It's a great visual.
Like, a thief who steals a shipment of laptops cannot pass a valid legal title to an innocent buyer because the thief never owned them in the first place.
Precisely. But if that rule were absolute, the modern economy would just grind to a halt.
Right, and this is where I see a major conflict for a bank. Let's say a bank issues a massive loan to a car dealership, and the bank takes a hypothecation charge over the entire showroom.
Very common.
The bank legally has a claim on those vehicles. But if a family walks into that dealership on a Saturday, buys a minivan, and drives it home, the dealership just sold an asset the bank had a claim on. If the dealership defaults on Monday, does the bank send recovery agents to repossess the minivan from the family's driveway?
They do not. And the legal mechanism preventing that is an explicit exception to the empty hands rule.
Oh.
Section 30, subsection 2, dictates that a buyer who is in possession of goods with the consent of the seller can pass good title to an innocent third party who buys them in good faith.
Wait, really?
Yes, this exception is engineered to protect the fluidity of everyday commerce. If stock is sold in the ordinary course of business, the innocent retail buyer takes it free and clear of the bank's encumbrances. The bank's hypothecation charge over that specific minivan basically evaporates the second the family drives it off the lot.
It's a massive vulnerability. It means the bank is entirely reliant on the dealership taking the cash from that family and depositing it back into the bank to service the loan. The physical collateral literally drives away.
Which is exactly why banks tightly monitor inventory turnover and require continuous stock reports. It also highlights a deeper concept within the Sale of Goods Act regarding who bears the ultimate financial loss when things go wrong. The guiding principle is risk follows property.
And just to clarify the terminology for you listening, property in this context doesn't mean a physical building. It means legal ownership.
Correct. The law separates physical possession from legal ownership. The rule dictates that whoever holds the legal ownership bears the risk of loss, regardless of where the goods physically are.
Okay.
So if a warehouse full of imported electronics burns down, the financial loss falls squarely on whoever held the legal property at the exact moment of the fire. And this specific dynamic, this assumption of risk, is the absolute structural backbone of Islamic banking in Pakistan.
Ah, that connects directly to a Mirabaja transaction, right?
It does. You see, a conventional bank simply lends money and charges interest. They don't really care about the goods themselves. But in Islamic finance, a murabaha is a trade, not a loan. For a murabaha to be Shariah-compliant, the Islamic bank must actually purchase the raw materials or inventory from a supplier. They must take legal ownership. They must hold the property.
And because risk follows property, the bank is absorbing the risk of that inventory being destroyed, even if they only hold the title for an hour before selling it to their corporate client.
Exactly. That assumption of risk is the entire legal and theological justification for their profit. If the bank never legally owns the goods, they never bear the risk. And if they generate a return without ever bearing risk, well, that profit is legally categorized as a disguised conventional loan, crossing the line into prohibited riba or interest.
Wow.
The strict application of the Sale of Goods Act is literally what validates the entire Islamic financial sector.
It is remarkable how a simple rule about a burning warehouse dictates the validity of a multi-billion-dollar banking framework. If we look at the journey we've taken through these statutes, there is a clear causal thread.
There really is.
We started by building the foundation of a deal, using the 5 fingers to construct a binding contract, and seeing how a simple signature can raise a time-barred zombie debt from the grave thanks to past consideration.
Right, and then we explored how coercion and psychological undue influence dictate whether a contract is born dead or merely dying, leaving the strategic power entirely in the hands of the victim.
Yeah. And then we transitioned into how banks bypass the delays of civil courts by utilizing the Negotiable Instruments Act, opening the 5 locks of an HDC to reverse the burden of proof.
And finally, we grounded those abstract concepts in physical reality, unpacking how the empty hands rule and the realities of commercial inventory exceptions force banks to constantly monitor their collateral, ultimately learning how the flow of risk defines Islamic finance. It is a highly engineered, interconnected system.
It is. Every clause is like a load-bearing wall.
Exactly.
Which brings me back to the scenario we opened with. We spent a lot of time discussing the power of the magic paper, the negotiable instrument that allows a bank to presume consideration and win in court. But the law is notoriously unforgiving. Under Section 87 of the Negotiable Instruments Act, there is a concept regarding material alteration. I call it the poison pen.
It is the ultimate cautionary tale for banking professionals.
Exactly. Think about it. If a bank officer holds a perfectly executed multi-million rupee promissory note but notices the date is slightly off, or the interest rate has a minor typographical error, if that officer takes a pen and makes a unilateral correction to the document without obtaining formal written consent from the borrower, that single stroke of ink is a material alteration.
Yep.
It acts as a poison that immediately and irreversibly voids the entire instrument against anyone who didn't consent to the change.
And the intention of the officer is completely irrelevant. I mean, they could just be trying to align the document with the truth of the original agreement. The law views the unauthorized alteration of a negotiable instrument as a fatal corruption of the document's integrity.
One unauthorized helpful edit can literally wipe out a billion-rupee recovery effort. The burden of proof shifts back, the magic paper turns to dust, and the bank is left totally empty-handed.
It's terrifying, honestly.
It is a stark reminder that in the realm of commercial law, there is no such thing as a harmless edit. Definitely something for you to think about the next time you are tempted to make a quick fix on a finalized document.